Hello everyone. Thank you so much to all our subscribers, viewers and followers for the immense love which you all have given us to the Vakil Vaani. I still remember when Himanshu and I were planning back in the April that we should do something of this sort. We recorded all the videos as well, but there was still a challenge to, properly bring it, edit it and post it. Now that we have finally did it, it has gone beyond our expectations. Thank you so much for that. And I really hope that this support of yours is always there. Thank you so much. Hello everyone. Today we have with us a very special guest, Senior Advocate Vivek Sood, sir. Sir has an immense experience of 30 years into the practice. Sir has argued not only the criminal cases but also the constitutional, commercial and civil cases. Sir has been the pioneer of the right to privacy, right to the freedom of speech and expression, and also about the right to the bail. Sir has authored n number of books related to the right to the trial, right to the bail, right to the freedom of speech and expression, and also about the economy of India. So today, in this episode, we have talked with Sir about what has been his challenges during the 30 years of practice, what all changes he has seen during the practice. So also in this episode, we have discussed the message which he wants to give to the young advocates. In this episode, Sir has also shared his view related to the elections which is about to come in the Delhi High Court. Please watch this episode, like, share and subscribe. Thank you so much. Good evening everyone. Welcome to another special episode of Vakil Vaani. So today we have with us Senior Advocate Vivek Sood sir, who is not only one of the favorite advocates of the young but also of all the seasoned advocates. He has been practicing not only in the courts of Delhi, either be it High Court or the Supreme Court, but also all over the India. He has been leaving his mark with his legal acumen. Welcome, sir. Sir, 3 decades of experience in the criminal law. You have seen changes in the criminal law, in the lawyers, in the judges, and everyone. How this journey has been, sir?
It has been a wonderful journey, and 3 decades have gone by as if they were 3 months, and I have a long way to go. I still feel very young, and I feel that I'm somewhere in the middle of my career. So, 3 decades looks to be a very long time frame, but I feel it was just the other day when I joined the bar. Yes, I have seen a lot of changes in the bar, in the way the judiciary functions, in the way the legal system functions, in the way the criminal justice system functions and malfunctions. I have seen a lot of change, but at the same time, many things have remained the same also.
We'll be
So,
discussing
so
more
it's
about
it's a
the
mixed bag. It's a mixed bag of change and consistency.
We'll be talking a lot more about the malfunctions for it. But sir, going ahead, sir, when you joined in 1992, sir, how was the advocacy then as compared to in 2024? 32 years, like at that time, what I have heard is like very difficult, no juniors, no Manupatra SCC. So how was the practice at that time, sir?
I would not say it was very difficult, but those were the times the way they were. So for research, we would go to the library and we would cull out the relevant books and we would research from the books that were available. For example, if we had to search for a proposition from the AIR or the Supreme Court cases, then, we would go through the subject index of every volume.
Okay.
But that was the way it was. So we never thought it was cumbersome or it was very difficult, because we did not know that the technology would make it very simple in future. So you live in the times, the way they are. But definitely now times have changed. You have the artificial intelligence, you have the search engine tools, you have everything available on your palm top, on your laptop, on your iPad. So, research has become far more efficient, far easier, and far more expansive,
Right,
and
sir.
far more efficient. So there has been a change over the last 3 decades or
Yeah.
so.
Very easily in a single click we can get whatever proposition we are looking for.
Definitely.
That's
Another change which I have seen over the last 3 decades when I started out in 1992 versus today, the approach of the judges towards the young lawyers.
okay.
I remember the judicial system was far more hostile, if I may say so, towards the young lawyers. There was a very, very clear Lakshman Rekha between the senior lawyers, senior counsel, or, aged lawyers and the young lawyers. Today, the system is far more democratic, far more accommodating towards young lawyers. Judges are willing to give a very patient hearing to one and all. So, I feel that democratization of the legal system has taken place over the last 3 decades or so.
Sir, I completely agree, sir. Otherwise, it would have not been possible for me, a young advocate, talking to a senior advocate. That is completely true. So, sir, what I have also read about you, that you have written books not only on privacy, not only on criminal law, not only on evidence law, but even on the corporate law, even on the different aspects of digital economy, the economy that India has been growing up with. So, sir, how that from different aspects you have been reading, writing, and as well as talking about it, sir?
So, first of all, I have always believed in diversity. I don't want to write something which is run of the mill. I have not written any law commentary, just, taking up the cases and analyzing them. I have written on issues. So whenever I found an interesting, fascinating, challenging issue to write upon, where I could contribute to the existing literature, contribute and take the law to another level, which we may call development of the law. So whenever I found something very interesting, something I could write on, I picked up those issues and I wrote on the subject. I did not care for the area of law I was writing on. So I've written on the law of privacy, I've written on cyber laws, I've written on the criminal justice system, I've written on commercial justice. So therefore, the diversity comes from my personality and my fascination for writing on newer issues, contemporary issues, futuristic issues, and not something which is run of the mill.
True, sir. And that can be clearly seen in this book of yours, The Chaff and the Grain. Sir, I recently completed this book and you have shared a lot of new perspective to the criminal law. So one of that perspective which is now growing is that the arrest justice, that the justice based on the arrest should also be there. So what exactly our viewers should know about this arrest justice?
I see a lot of welcome changes in the way the criminal justice system is functioning today. Judges have become very sensitive and conscious of people being arrested without necessity, people being unlawfully arrested without a cause, and other things. Of course, much more needs to be done. It's only the tip of the iceberg, I would say. But I can see green shoots. So, when I was writing Chaff and Grain, I had about maybe 28 years of experience behind me. And I would realize that when a man is arrested and is brought before the magistrate, if he is declined bail, he is sent to police custody or judicial custody. The legality of the arrest, the legitimacy of the arrest is lost in the maze of the criminal justice system, and the whole focus of lawyers, prosecution, state, judges, the focus shifts on bail. But the legality of the arrest was never adjudicated upon. So therefore, I found that subject to be very interesting. So I've written about it in spite of the Supreme Court saying time and again since 1992, Joginder Kumar's case, 2016, Arnesh Kumar, that, people are arrested left, right and center by the police without necessity. So therefore, I found that subject to be very interesting. I wrote about it, and now I see, that there is a change in the attitude of the judges. Of course, we need much more change than what it is today, but the whole system is becoming more and more sensitive and conscious towards arrest justice. So I've coined this expression, arrest justice. It is my expression which I've coined, which you are using today. It was used for the first time in Chaff Grain.
Exactly, sir. I learned from this only. Sir, there is one more term which you have coined in this book, and which now to sir has been used by everyone as well. That is the malvestigation, wherein you have talked about the investigation, the police, how they are doing it, the charge sheet which are filed. So, sir, what exactly it is which the audience should know about malvestigation?
Malvestigation is, in simple terms, incompetent investigation, unscientific investigation, corrupt investigation, dishonest investigation, shortcomings in the investigation. I have coined this expression. I found I always like to be creative. So I wanted to coin an expression. So I found this word malvestigation to be very appropriate. So, in this chapter on malvestigation, I have picked up some very important cases: Jessica Lal, Priyadarshani Mattu, the Telgi scam, and some of these important cases, Arushi Talwar murder case. So I picked up these cases and I have analyzed how the investigation was manipulated, or how dishonesty was brought into investigation, or where was the incompetence in the investigation, shortcomings in the investigation, and how the system overlooks it. When the investigation is being conducted, when there are shortcomings in the investigation, there is no check or balance while the investigation is being conducted. But after 25 years, when the matter is in the appellate court, after 25 years, the High Court or the Supreme Court will say, oh my God, the investigation was a malvestigation, the investigation was unscientific, incompetent, dishonest, corrupt. But that's a very theoretical observation. The system does not change. The system will change only when, while the investigation is being conducted, there is a vigilant eye on the quality of the investigation. For example, in the RG Kar case in Kolkata, right, the SHO of the police station and other functionaries have been arrested, right, on the allegation of malvestigation. So,
sir, when you have been saying that the system should change, sir, which system are we talking about? Either it's the police system, the judicial system, because, sir, I want to just talk about something that you also even mentioned, that it's when the matter is before the magistrate and the session court that malvestigation is overlooked. When it comes to the High Court and the Supreme Court, at that time when 20 years have passed and now it is realized that, okay, sir, is it the competence of the lawyers? Is it the competence of the judicial system in the city limits that the thing is not coming out?
I would primarily affix the responsibility, firstly on the police, and secondly on the judiciary. Definitely also on the legal community to some extent. Now, I'll just explain. For example, the police in India, in my view, is still very, very colonial in their attitude towards the citizens. And I'm not saying it, the Supreme Court has said it time and again, that the police in the country is very colonial in character. So we need police reforms. Now, police reforms include legislative reforms, executive reforms, and the reforms within the police system itself, internally. That's one part. Secondly, I come to the judiciary. We need a lot of reforms in the judiciary, especially at the level of the magistrate, where the accused is first produced after being arrested. The magistracy of the country. I'm not saying the Supreme Court has said time and again, for instance, in Arnesh Kumar, that the magistracy of the country is also very colonial in nature. Their approach is sometimes very, very indifferent towards Article 21, towards liberty, towards the accused, etc. We need reforms in the judiciary as well. Then I come to the legal community.
Yes.
I find that, a large section of the lawyers who are defense lawyers, they are not very, very competent when it comes to cross-examination of witnesses. That's a problem that comes from the legal education. Cross-examination, in my view, is a dying art. It's a dying science. Many lawyers in the trial court don't understand the nuances of cross-examination. It's not their fault. Cross-examination should be made an integral part of the law curriculum. It should be given more importance than any other subject during the LLB program. So, we need all-round changes across the entire spectrum. We need more judges. So, therefore, that's where the executive comes into play. We need to multiply the judges maybe 10 times in the country. If all the the pendency of cases has to be dealt with, or if we need a resolution to that, we need to multiply the number of judges. That's where the law ministry, the executive, the government, the collegium, the high courts, the Supreme Court, the entire legal system comes into play. So we need all-round changes. So while good things are happening across the spectrum, we need a lot of reforms at the same time.
Sir, I remember when you're talking about the cross-examination, I want to share it with everyone as well. Sir, in our college days, late Senior Advocate Ram Malani sir used to come and give us the lecture in Pune. So he used to talk a lot about the cross-examination. He was one of the experts in the criminal trials and everything. So, sir, he used to say that all the trial lawyers during their cross-examination should learn where to stop before starting.
Absolutely.
So, what are your views as to
the
cross-examination?
I totally agree with Mr. Malani. He was an institution in criminal law, in jurisprudence, in constitutional law. So the saying is that, more than what to ask, you must know what not to ask. So, many a times I see that the lacunas in the case of the prosecution are being filled up by the defense lawyers through their cross-examination, through excessive cross-examination of the witnesses. So therefore I say that, cross-examination is a dying art, it's a dying science, and it should be given more importance than any other subject in the law program. It starts from the LLB program, and see what the crop you will have is based on the seeds that you sow.
I completely agree. I would like to tell all the audience there that sir, having a very busy schedule, is fond of golf, the gym, the workout. So sir, how are you maintaining the work-life balance? Because we ourselves right now saw that there are lots of briefing and meeting schedule. How are you dealing with
golf is out of the picture now. Golf, I have not played golf for the last over 2 years. So it is out of my portfolio. Workout also, I would hit the gym. I would try and go to the gym maybe 4 or 5 days in a week to the Noida golf course or the Friends Club or, somewhere. But time does not permit me to do that also. So therefore, as a stopgap arrangement, I have set up a small gym in my office and I get a trainer. He comes thrice a week and I spend about 40-45 minutes with him. And I do some yoga in the morning at home, half an hour, 40 minutes. So in bits and pieces, I try and look after myself. I'm 56, so I need to look after my health. Health for me is the only real wealth. When you come to my age, you realize the importance of health. Health is not wealth only. Health is the only real wealth in my view today. So therefore,
Golden
and
words to
then
look
then
for.
my time with the family has also shrunk. But then we do find time for holidays. I do find my time to read a book or have a cup of coffee
So,
with a
which is
good
your
friend.
favorite destination for a holiday in
Uh,
India and also abroad?
I like to go to places where there's more nature than the malls, whereas my family wants to go to places where there are more malls and there's more activity. I like to go to quieter places. So I have a long list waiting, but let's see when in life I can do that. Maybe
that is
for example, I've been planning to do something called the Walk Japan. So there is a 12 to 15-day trek. It's a trek where you live in the mountains, in the old inns that have been there for about 7 or 8 generations. So I want to do Walk Japan. Let's see when the time will permit me to do so.
Delhi High Court vacations are coming,
So
sir, in
let's
December.
let's see. I don't know.
All right.
I don't know.
Sir, now taking ahead, my colleague Himanshu will take it from here.
Very well.
Okay, sir. It was really nice talking to you. Thank you so much.
Thank you, Simarjeet. It was a lovely opening. Now I'll take this ahead, sir. First of all, best of luck for your forthcoming election as you are contesting for the post of president in the Delhi High Court Bar Association. Sir, what is your manifesto in the election?
I will be brief because because of the time in hand. First of all, it is accessibility.
Yes.
I will, if elected, I will want to be accessible to every member of the bar, especially first generation young lawyers. So for me, accessibility is a very important facet of leadership.
Yes.
Secondly, I will want to be the voice of the bar. There are so many issues that need to be taken up with the establishment, with the government, with the Chief Justice, with the judges. There are so many issues. For example, chamber allotment, enhancement of infrastructure, making of more bar rooms,
Yes.
for lawyers at large. And for example, the chamber allotment. Now, there is a waiting of about 25 years before you get a chamber. And that waiting time frame is only increasing. So, why don't we have bar rooms, large size bar rooms to accommodate, say, 100 lawyers at a given point in time where they can confer with the clients? Then there has been a long-standing proposal that the areas around the Delhi High Court should be acquired by the government and added to the campus of Delhi High Court.
Yes.
I will want to activate that. Then the Wi-Fi connectivity is sometimes, not too great in the High Court. I will want that infrastructure to be enhanced. Insofar as young first generation lawyers are concerned, I will ensure that some kind of a level playing field is created for them. For instance, the local commissioner appointments are there. So the preference should be given to young first generation lawyers, or the legal aid briefs are there. Preference should be given to young first generation lawyers. Amicus briefs are there, where the courts appoint amicus. Friends of the court, there also preference should be given. Then, when a young first generation lawyer comes to the High Court, he has no guidance, he has no support system, he does not have the wherewithal to join a good chamber of a senior counsel or a law firm. I will want to provide that mentorship, that guidance to the young first generation lawyer so that he feels comfortable. See, the struggle for a young first generation lawyer is something that is very, very close to my heart. I feel very sensitive about this. So young first generation lawyers have to be promoted in my view, and I will do everything under the sun to promote them, to make them feel comfortable, make them feel happy. You will not know, but I will tell you, many young first generation lawyers just leave the profession quietly. After 2 years or 3 years,
Yes.
they take up some other jobs
Yes.
because they feel so discouraged, by the system. So I will try and improve that system to the best of my ability with all humility. I will do anything possible, everything that is possible to promote the young first generation lawyers. Similarly, for female lawyers at the forefront of the legal profession today. You have female lawyers who are heading law firms, who are partners, and you have, lady judges who are far more in terms of number than when I started in 1992. You have many more female lawyers who are designated as senior counsel, but much more needs to be done. Still, the ratio between female lawyers to male counterparts in terms of elevations, in terms of designation as senior advocates, still the ratio is quite lopsided. The ratio must increase. So therefore, I will want to take up some of these issues with the establishment, to enhance the Delhi High Court bar in totality, holistically. Similarly, there are many other issues that I have in mind. So if elected, I will do my best to promote those issues and to bring them to the fore and try and find some resolution to all these problems.
Yes, sir. So going ahead, sir, you have written a book on criminal justice system. So what are the major pillars of criminal justice systems?
For me, the most important pillar of criminal justice system is fair trial. Article 21, life and liberty, for me is the pillar on which the criminal justice system is founded upon. The foundation of the criminal justice system is Article 21. Article 21 has so many rights encapsulated within it. So therefore, I am all for liberty. I am all for fair investigation. I am all for fair trial. I am all for bail, not jail. But not as an absolute. In certain cases, there should be jail, not bail also. But broadly, I am, I'm all pro liberty. So therefore, these are some of the pillars of the criminal justice system.
So, going ahead, how much a criminal justice system can be influenced?
I will not want to, go into this issue very critically. I would say that there are issues, there are problems, there are stories of influence, or in many cases you see that there is an element of influence that may have entered into the case. But I can't make a comment at a macro level.
Okay.
Maybe we can have this exercise, we can have this debate with respect to individual cases. At a macro level, the criminal justice system is functioning.
Okay.
It is malfunctioning also, but it is functioning also. Criminal justice is being delivered. You can't say that the whole system is unjust or something like that. Criminal justice does happen every day. We see in thousands of cases. There may be aberrations, there may be different viewpoints. These are also value judgments. What I perceive as criminal justice, you may perceive it as something injustice. So it's also a game of perception. But with 32 years of experience behind me, the system is functioning. I can't call it that there is a collapse. Yeah, there are some pandemic problems in the criminal justice system. For example, perjury by witnesses. Now, it's a very big problem. The Supreme Court has said so time and again that they don't find a single witness who does not commit perjury, whose testimony, whose evidence does not carry falsities, embellishments, manipulations, embroideries. That's a very big problem. So now that problem can be resolved partly by law, by activating the law against perjury, start punishing people, start punishing witnesses who lie under an oath, so that there is deterrence in the system. Also, it is a social problem. We, the people of India, we have to improve our credibility. We have to speak the truth when we come into the witness box. After all, we take an oath before entering the witness box. That oath has to be meaningful. It is not, should not be an empty formality. You take an oath and then you lie on a platter thereafter. So these are some pandemic ills that confront the system, and society must change. The whole attitude towards giving evidence in the court, the whole approach has to change. So these are some of the issues that need to be addressed.
So we being a lawyer sees क्रिमिनल जस्टिस सिस्टम काम कर रहा है. हम लोग हर रोज एक नया जजमेंट, एक इफेक्टिव जजमेंट आता हुआ देख रहे हैं. बट ऑन ग्राउंड रियलिटी अ लेमैन, अ कॉमन मैन हैव अ परसेप्शन कि अमीरों के लिए कोई कानून नहीं है, पिस्ता सिर्फ गरीब.
I don't agree with this proposition, in totality. I will not want to make a statement again at the macro level. You can't say that the rich and famous get away with everything and it is only the poor man who suffers criminal injustice or something like that. Again, it's a value judgment. Okay. The rich people are definitely in an advantageous position. They have the best of defense lawyers, they have the battery of lawyers behind them, and then they also, tend to use, or they attempt to use their influence because of their richness. I have seen that, we see that happen. But at the same time, they're also at a disadvantage because being rich, the system feels, oh, you are a rich man. Oh, let's teach you a good lesson.
Yes.
So there have been instances where the rich people are also victimized. So you can't generalize.
Yes.
You can maybe, for example, in the Pune accident case,
Yes.
the boy got arrested, his family members got arrested. Even the doctors or some other people, experts who tried to manipulate, the driver got arrested, who tried to manipulate the case, they all got arrested. Where is the richness gone? Where is the money gone? Now another example, the Supreme Court in Satinder Antil's case has said, bail should be granted. Bail is the rule. Jail is an exception. Grant bail to more and more people. Why isn't bail being granted? But then they say, and exceptions are there. One of the exceptions is white-collar crime, economic offences. So the rich are at a disadvantage over there, and the poor are at some advantage over there. So it is not. It won't be fair to make generalizations or to make a statement, a hard-hitting statement that the rich get away with everything. It is not so.
They only have advantage to some
They
extent.
have advantages in terms of defending
Best,
themselves.
getting best.
Yes.
So going ahead with, what are your thoughts on media trial?
Yes, media trial in a democratic society will always be there. You cannot wish it away. You cannot wish it away, especially in today's media, where every netizen, every citizen is a broadcaster,
Yes.
and the audience is a global audience. The media houses, before the internet came, was in the hands of few individuals, few corporates, maybe 100, 200, 500, 1,000, 10,000. Today, every person who has an internet connectivity is a media house.
Yes.
So therefore, he will comment. In a democratic society, you have free speech,
Yes.
freedom of speech and expression. So media trial will always be there. Judges have to be careful that they don't get influenced by the media trial. Judges, especially at the district court level, again, I am not generalizing, do tend to get influenced by the media trial. They feel, oh, this case has got so much of media attention. It is better for me to deny him bail. Let the High Court grant him bail or the Supreme Court grant this man bail. I should not touch it. I should not get it. So it's a more comfortable way of doing justice by dismissing the bail application, and you leave it for the superior court to deliver justice. So these things are there in the system. Again, I would not want to make a generalization out of this media trial. It was there, it is there, it will always be there. We have to live with it, we have to live with it, we have to live with it.
Sure. So, sir, you have been practicing for more than 3 decades. So, what challenges you faced in your initial years?
When I started out in 1992, there were a few challenges, although, I am not a person who likes to crib about anything in life. I like to just look at life the way it is, in a positive frame. The challenges make you stronger. The challenges make you realize the importance of what you have on the table. So challenges, have their own positives. But some of the challenges which I faced was, I thought the judiciary in those times was not very, very open to hearing young lawyers. You had to actually make yourself heard. And so that was one challenge. The judiciary was a bit hostile towards young lawyers, which it is not today. Fortunately, the judiciary today is very, very open-minded, and they want to give a hearing to all lawyers, irrespective of their stature or the age, etc., etc. Okay. Now, in terms of research, it was a bit of a challenge, but then we accepted it happily. It was not something that I will want to change, go back and change it. So I really I can't really say what were the challenges. Yes, financial challenges were there. We as juniors would never get paid. We never got paid. The clients never paid the juniors properly. And then the profession was considered to be an old man's profession. I remember when I started, I would, pray to the Almighty, please make me an old man at the earliest so that I can flourish in the profession. Not anymore. The young lawyers are doing very well today. So the financial challenges were also there. And that's about it. Otherwise, when the going gets tough, the tough get going. So, the challenges were there, but then they made you stronger.
Yes. So, what piece of advice you would like to give to the junior advocates, fresh advocates, and the law students?
I would want to say that they need to cultivate perseverance. They need to be patient. They need to wait for the time to come. Secondly, I feel that, they need to work harder. They need to burn the midnight oil more often. And these are the two things I would, and then, okay, one more aspect which I would want to highlight. I want to see, that the young lawyers are also, they're also doing criminal trials, they're doing civil trials. They're not only focused on arbitrations or appellate work. They should also slog it out in the trial courts, learn the art of cross-examination, conduct trials, cross-examine witnesses, all of that, rather than focus on the bail practice or the quashing petition practice or some of those, easier parts of the profession. These are some of the areas where I feel the young lawyers could do much more, and I will advise them to do much more, although they are far more intelligent than what we were when we started out. and they are much smarter, they are much more confident of themselves, and they are more vibrant, they are more proactive. So I see them much better than my generation at the same time. So this is how I would see the young lawyers in the making. They are the future of the bar. They are the future of the judiciary.
Thank you so much for your time, sir. It was an insightful session, sir.
Thank you. Thank you. Thank you very much.